Unpaid seller. Seller of goods is deemed to be an unpaid seller when 1. The whole of price has not been paid or tendered, and seller had an immediate right of action for the price. 2. When BOE or other NI has been received as conditional payment, and condition on which it was received has not been fulfilled by reason of dishonor of instrument or otherwise. Seller includes any person who is in the position of a seller. Rights of an unpaid seller. Rights of unpaid seller against the goods. 1. Seller's lien. Unpaid seller has right of lien on goods for the price while he is in possession, no lien, until the payment or tender of price of such goods. It is the right to retain possession and refusal to deliver until price due is paid or tendered. Lien can be exercised even where he is in possession as agent or bailee for the buyer. This right can be exercised by him in following cases only. A. Where goods have been sold without any stipulation of credit, that is, on cash sale. B. Where goods have been sold on credit, but the term of credit has expired. Or C. Where the buyer becomes insolvent. Part delivery. Unpaid seller has made part delivery. He may exercise lien on remainder, unless such part delivery has been made under such circumstances as to show an agreement to waive the lien. Termination of lien. The unpaid seller loses his right of lien under the following circumstances. 1. When he delivers goods to a carrier or other bailee for the purpose of transmission to the buyer without reserving the right of disposal of goods. 2. Where buyer or his agent lawfully obtains possession of goods. 3. Where seller has waived the right of lien. 4. By estoppel. That is, where seller by conduct leads third parties to believe lien does not exist. Exception. Unpaid seller does not lose his lien by reason that he has obtained a decree for the price of the goods. 2. Right of stoppage in transit means right of stopping the goods while they are in transit, to regain possession and to retain till the full price is paid. This is an extension of lien as it entitles to regain possession even when parted with goods. It is exercised only when the following conditions are fulfilled. A. The seller must be unpaid. B. He must have parted with the possession of goods. C. The goods are in transit. D. The buyer has become insolvent. E. The right is subject to provisions of the Act. Duration of transit, from the time when they are delivered to carrier or other bailee for transmission to buyer, until buyer or his agent takes delivery of them from such carrier or other bailee. Right of stoppage in transit is lost or comes to an end in the following cases. 1. When buyer or other bailee obtains delivery. 2. Buyer obtains delivery before arrival of destination with or without consent of carrier. 3. Carrier or other bailee acknowledges to buyer or agent that he holds goods, unless seller has reserved right of disposal of goods. 4. Carrier wrongfully refuses to deliver goods to buyer. 5. Goods are delivered to carrier hired by buyer. The transit comes to an end. 6. Part delivery made to buyer. Transit will end for remaining which are in transmission. 7. Goods are delivered to a ship chartered by buyer. Transit comes to an end. Right of resale. 1. If goods are of perishable nature, buyer need not be informed of intention of resale. 2. Where notice is given to buyer of intention to resell, and after receipt, buyer fails within a reasonable time to pay or tender the price, the seller may resell the goods. On resale, seller is entitled to 1. Recover the difference between contract price and resale price from buyer as damages, and 2. Retain the profit if RP is higher than CP. The above is possible only if notice is given for resale. If resold without notice, seller cannot recover the loss on resale. Also, profit if any be returned to original buyer. 3. Subsequent buyer acquires good title against original buyer, despite the fact that notice of resale has not been given by seller to original buyer. 4. Seller is said to have reserved his right of resale if it is expressly agreed between parties that in case of buyer's default in payment, seller will resell the goods. Also, no notice is required in resale, and also entitled to recover damages without notice. V. If property in goods has not passed to buyer. Unpaid seller has in addition to his remedies a right of withholding delivery of goods. This right is called quasi-lien. This is an additional right used in case of agreement to sell. 4. Rights of unpaid seller against the buyer. The rights of the seller against the buyer personally are called rights in personam and are in addition to his rights against the goods. The right against the buyer are as follows. 1. Suit for price. In case of sale, if property has passed to buyer, he wrongfully neglects or refuses to pay according to terms of contract, seller may sue him for price of the goods. In case of agreement to sell, if property has not passed to buyer, but where price is payable on a certain day irrespective of delivery, and buyer wrongfully neglects or refuses to pay, seller may sue him although goods have not been appropriated to the contract. 2. Suit for damages for non-acceptance. Where buyer wrongfully neglects or refuses to accept and pay, seller may sue him for damages for non-acceptance. 3. Repudiation of contract before due date. Where buyer repudiates the contract before date of delivery, seller may treat the contract as rescinded and sue for damages for breach. Anticipatory breach. 4. Suit for interest. If specific agreement between parties as to interest on price of goods from the date on which payment becomes due, seller may recover interest from buyer. If no specific agreement, seller may charge it when it becomes due from such day as he may notify to the buyer. If absence of contract to contrary, court may award it in a suit at such rate as it thinks fit from the date of tender of goods or from the date on which price was payable. Remedies of buyer against the seller. 1. Damages for non-delivery. Where seller wrongfully neglects or refuses to deliver the goods to buyer, buyer may sue the seller for damages for non-delivery. 2. Suit for specific performance. Buyer can appeal to court for specific performance. Court can order this only when goods are ascertained or specific. This remedy subject to following conditions. A. Contract must be for sale of specific and ascertained goods. B. Power of court to order. This is subject to provisions of Specific Relief Act 1963. C. It empowers court to order it where damages would not be an adequate remedy. D. It will be granted as remedy if goods are of special nature or are unique. 3. Suit for breach of warranty. Where there is breach of warranty or buyer elects to treat breach of condition as breach of warranty, buyer is not entitled to reject the goods, but he may set up against the seller the breach of warranty in diminution or extinction of price, or sue the seller for damages for breach of warranty. 4. Repudiation of contract before due date. Where either party of sale repudiates the contract before date of delivery, other may either treat the contract as subsisting and wait till date of delivery, or he may treat contract as rescinded and sue for damages for the breach. V. Suit for interest. Nothing in this act shall affect the right of seller or buyer to recover interest or special damages, where by law it may be recoverable, or to recover the money paid where consideration for payment has failed. In the absence of a contract to contrary, court may award interest at such rate as it thinks fit from the date on which payment was made. Auction sale. It is a mode of selling property by inviting bids publicly, and property is sold to highest bidder. An auctioneer is an agent of seller governed by the law of agency. He may sell his own property as principal, and need not disclose this fact that he is so selling. Legal rules of auction sale to regulate the sale by auction. A. Where goods are sold in lots, each lot is prima facie deemed to be subject of a separate contract of sale. B. Completion of contract of sale. Sale is complete when auctioneer announces its completion by fall of hammer or in any other customary manner. Until such announcement, any bidder may retract from his bid. C. Right to bid may be reserved. It may be reserved expressly by or on behalf of seller, and where it is done so, seller or any one person on his behalf may bid at the auction. D. Where the sale is not notified by seller. Where sale is not notified, it shall not be lawful for seller to bid himself or to employ any person to bid, or for auctioneer knowingly to take any bid from seller or any such person, and any sale contravening this rule may be treated as fraudulent by buyer. E. Reserved price. The sale may be notified to be subject to a reserve or upset price. F. Pretended bidding. If the seller used pretended bidding to raise the price, sale is voidable at option of buyer.